Speaker, my question is to the Attorney-General and asks, does he stand by his statement that 2,000 kilometres of coastline could be put into customary title?
The Honourable Chris Finlayson.
If the member reads the transcript from the relevant interview, he'd see that the figure came from the interviewer, not me. I agreed the figure would be an in-the-round guesstimate of that. It could be less than that figure, of course. It's going to depend on iwi entering into negotiations or making an application to the court, and it's going to depend on the facts as presented at any negotiation or in court.
Mr Speaker.
The Honourable Jim Anderton.
Mr Speaker, as the Minister's long answer seems to be a long way of saying yes, is handing over the title of up to 2,000 kilometres of land that belongs to all New Zealanders, consistent with the statement by Jerry Brownlee made on the agenda program on the 10th of March 2007 that, quote, National has made its position on this clear right from the start. We believe our beaches and our lakes should belong to all New Zealanders, end quote.
Mr Speaker,
the Honourable Jim, the Honourable Chris Finlayson.
The position's absolutely consistent with what Mr Brownlee said. What we are talking about is customary title. The member's question seems to assume it's some kind of fee simple title, and that's wrong.
Supplementary.
The Honourable Jim Anderton.
Mr Speaker, how then is the explanation of the Minister to the primary question consistent with the statement by Jerry Brownlee on Morning Report on the 17th of July 2007 that, quote, Labor has traded away the birthright of all New Zealanders and the unrestricted ownership through the Crown of all foreshore and seabed and turned it over to racially based control, end quote.
The Honourable Chris Finlayson.
Public access is guaranteed and a new form of customary title will be developed and that is the position under the current regime. I'm not interested, as that member is an expert in and delving into ancient past. I'm dealing with the present and the future.
Supplementary.
The Honourable Jim Anderton. Order. I've called the Honourable Jim Anderton.
Supplementary, Mr Speaker. If the Minister is not interested in the two quotes I've already made from Jerry Brownlee, how can any of his attempted explanations about handing over the title of up to 2,000 kilometres of land that belongs to all New Zealanders be consistent with the statement of Jerry Brownlee made on Eye to Eye on the 7th of July 2007 that, quote, National says the beaches should belong to all New Zealanders and we oppose race-based legislation, end quote.
The Honourable Chris Finlayson.
The member in his dotage here is becoming more and more garrulous.
Order. There'll be no... I'm on my feet. I've got to say to the Minister that answer is totally unacceptable. The member cannot abuse another member just because they ask a question. The member, if I recollect, the member asked the Minister how he reconciled the government's position with an earlier statement made by a senior colleague. Now that is it might have political overtone, but it doesn't deserve abuse of the questioner. The House is actually interested in hearing the answer. The Honourable Chris Finlayson.
Mr Speaker, where we get to today is as a result of an agreement after the 2008 election with the Maori Party. A review was conducted of the Act, and what we are trying to do is come up with a proposal that takes this country forward, and I would hope that the honourable member would be interested in joining with us on this rather than being so destructive and negative.
David Garrett.
Supplementary to the Attorney-General. Can he guarantee the public not just access to the foreshore and seabed under customary title, but free public access, and that no iwi or hapu will be permitted to charge members of the public who are enjoying traditional customary leisure activities on the foreshore and seabed under
the Honourable
customary
Chris
title?
Finlayson.
If anyone is enjoying a customary leisure activity on the foreshore and seabed, I've already made it abundantly clear that public access is guaranteed, and I cannot for the life of me conceive of any reason why there would be charging for the average New Zealander enjoying public access along the lines of what the member said.
Point of order, David Garrett.
Mr Speaker, I listened to that answer very carefully. The question began with, can the Attorney-General guarantee? His answer at the tail was, I can't for the life of me see.
Order. We've heard sufficient. I mean, when members ask ministers whether they can guarantee issues like that, it's extraordinarily difficult to... Well, the member cannot expect a yes-no answer to a guarantee like that. I think the minister gave a reasonable answer to the member's question. Te oroa Flavel.
Tēnā koe, Mr Speaker, kia ora tātou, ko te reo Māori tēnei. To the Minister, ki te minita, kei te whakaia atu ia ki tā te roia Māori, a Moana Jackson kōrero, nā te teiteira wā atu o te taumata mo te customary title, te taia te whakatutuki, ki te kore, hea ana kupu ātawhai ki ngā whānau, ki ngā hapū, ki ngā iwi.
The Honourable Chris Finlayson.
The translation was not very helpful, I regret to say.
Could I? It's perhaps the minister especially didn't hear the early part of it. Would the member mind assisting to make sure the minister does understand the question?
Kei te pai, Mr Speaker. To the minister, does he agree with Māori lawyer Moana Jackson that the standard that has been set for proving customary title is so high that it is practically impossible to meet? And if not, what assurance can he give whānau, hapū and iwi otherwise?
I thank the Honourable Member, the Honourable Chris Finlayson.
Mr Speaker, I thank the Honourable Member too. Look, there are doubtless going to be some iwi who can meet the test for customary title. Any application to the courts or any negotiations is going to be able to be dealt with on the facts, unlike what happened under the 2004 Act. And while many iwi may be unable to obtain a customary title under the new tests, they will still be able to enter into negotiations to obtain recognition of customary interests.
Te ora Flavel.
Reo Māori, hea tāna whakautu ki tā te roia a prū kapua kōrero, he tino taiapa te nui o te utu, ki te kawe i te take nei, ki te kōti teitei, mō ngā iwi me ngā hapū.
The Honourable Chris Finlayson.
My answer is that all litigation's expensive, but the High Court option is the best option because of the lack of availability of judicial review, the ability of the High Court to sit with experts, the ability of the High Court to refer matters to the Māori Appellate Court, or if there are questions of tikanga or fact, and the limited number of appeals. So I believe that the High Court route is ultimately the less expensive.
Question number 11, Katrina Shanks.
Thank you, Mr Speaker. To the Minister of